further hearing in the appeal of Dallah Real Estate and Tourism Holding Company against the Ministry of Religious Affairs, Government of Pakistan.
Yes, Ms. Halbrand.
May it please your Lordship, I was indicated that I would move on to deal with the legal issues, and I also indicated that I wouldn't spend a lot of time on what was parts 3 and part 4 of my case. I would just like, if I may, just to spend perhaps 5 or 10 minutes on that and then move straight to the issue. Just to highlight a few points, because I'm assuming your Lordships are now familiar with it. The scheme of the New York Convention, as you all know, has a pro-enforcement bias. And I draw particular attention to Article 3, which is mandatory, which has been incorporated by Section 101 of the 1996, which makes it incumbent upon a contracting state to recognise arbitral awards as binding and enforce them. And the only exception to that is under Article 5, or we're not dealing with it today, the public policy issue, which gives very limited grounds, but still retains a residual discretion. And when I come to deal with discretion, I'll come back to this, but you will have noticed that the phrase is may be refused rather than may be enforced. And the other point to emphasise, which we did discuss yesterday, but in the context of the enforcement, the onus remains on the government, the objecting party. And as your Lordships know, in this country and elsewhere, it's very rare that New York Convention awards are not enforced, and this is, I believe, only the second case where this has happened.
And the rationale of this is the one that we discussed in Dallah and UKSC, namely that something that looks like a valid award is to be taken as is unless the contrary is shown.
As your Lordship set out in Dallah, indeed, yes.
But then
An apparent validity for the purpose of the mechanistic introductory approach. And it is then stated, though, that the award is mandatory, and that Article 3 is important, or Section 101 to that effect. But the grounds upon which that mandatory binding nature can be challenged are very circumscribed by Article 5.
But if one reaches a conclusion, assuming the onus is satisfied that the agreement was not valid, do you still say there's a discretion?
I do still say there's a discretion. Because of
a bias in favour of enforcement of an invalid agreement.
Because of the bias in favour of enforcement. Because when we come to discretion, we will see, and I'll take you through it, I'm sure you're familiar with it, but the different parts of the New York Convention distinguish between shall and may. Shall was originally in Article 5 and was removed, and therefore there must be a reason why there is that residual discretion. Because
we explained a reason which was consistent with legal principle in Dallah and UKSC. You can have subsequent events and so on, which, so to speak, stop or preclude a party.
Well, that is obviously one of the circumstances, but my Lord, when I get to that, I will try to seek to persuade your Lordship that actually
it's much broader.
The principle can be wider. It's not arbitrary, obviously, but it can be wider. But I was going to leave that to the second stage, and I was really just at the moment laying the groundwork for the first point, which is the review point. The second point I was just going to make, again, just summarising what's in sections 3 and 4 of my case, that an award can only be set aside at the seat of the arbitration. When an award is set aside, that in itself provides an independent ground under Article 5 for refusing enforcement. And in this case, France being the seat, it can only be set aside in France. The difference being when you're seeking to enforce, and this is an important point, when one's seeking to enforce an award, it can be enforced in any one of 144 countries. And therefore there is scope for diversity unless principles are established which would undermine the effectiveness of the New York Convention. There are, just to make it clear, I accept there is no obligation on a party to go to the seat to have the award set aside. There are two options, but the options present a choice to that party, and that party may find that if it elects not to go to the seat, the grounds upon which the award can be challenged are more limited. In England, you have Section 67. In other countries, you may have a much wider review of different grounds. It will vary from country to country. But when you come to the enforcement, in many situations, though not in all, in the model law, the grounds are the same, but in some situations, the grounds under Article 5 will be less. And so that party has to take a decision, and it's entirely up to that party, whether it wants to restrict itself to the Article 5 grounds or go earlier to set it aside. But I make it clear it's not an obligation to do that.
Is there a different standard then as between recognition and enforcement, or is it proposition spreads across the two?
Well, between setting aside and recognition on the one hand and recognition and enforcement on the other hand, there may be different standards. It will depend upon the countries. Some countries give a much wider brief to what you can take into account. Section 67 is not really limited in determining whether or not there is jurisdiction. Other countries which have adopted the model law, Article 34 and 36, Article 34 deals with annulment, 36 is enforcement, have the same principles. So it depends on different situations. But here in France, when you apply to set aside, it's a wide review. But when you come to the enforcement is limited to the Article 5 grounds. In other countries, it might be different. So the point I'm making is I'm not saying that the government had an obligation to go to France. But what I am saying is that by not going to France, it elected to choose to take its chance with an enforcing court, which may not necessarily have been England. It could have been anywhere in the world of the 144 countries.
Isn't there a lurking inconsistency of attitude here? I mean, at certain parts of your case, you stress how transnational and supranational arbitration is, and really the place of the seat of the arbitration is irrelevant. It's all subject to transnational considerations, and yet you say as soon as you go transnationally, you find that the seat becomes rather important, and that you're worse off when you seek to resist enforcement than you would be in the place of the seat.
Well, not necessarily. In some cases you might, that's all. It will depend upon what the law of the seat is. But the point being that I'm not saying that one has primacy, although some of the American courts describe one as primary and the other as secondary. But if you go to the court of the seat, and you succeed, the great advantage is it gives you a second bite at the cherry, so to speak, when you're seeking to enforce, because it gives you an additional ground. So that if, for example, in this case, the government had gone to France and had the award set aside, and we had sought to enforce, they would then have been able to say, not only is it not valid, but also it's been set aside at the seat. That's really as far as I need to take it for today's purposes.
But that, as you say, that contemplates the possibility of it being set aside on grounds which actually have nothing to do with jurisdiction, on the merits, for example. And one can well understand the specific provision in the New York Convention as catering for that sort of situation. We have appeals in arbitration cases in this country.
Well, my lord,
if the award has been set aside, then obviously that's a pretty fundamental defect. But one would have thought that it would be strange to have distinctions between different countries as to the approach when the issue is a different one, namely whether there's an arbitration agreement at all, effectively.
Well, with respect, I don't want to spend too long on this, but if you take the English situation, Section 67, if it's set aside, if one had a reverse situation, if it was set aside in England under Section 67, and we were seeking to enforce, it was an English seat, and we were seeking to enforce in France, the government was seeking to of Pakistan was seeking to enforce in France, it would then be able to say, but the English courts have set it aside, and that's an extra ground. The English courts under Section 67 do a complete rehearing, and it isn't circumscribed.
Yes, well, that was my point. That's why you've got this specific provision to cater for that sort of situation. To deploy it as a reason for limiting jurisdictional review seems to me not to follow.
I don't think, with respect, I was actually saying the reverse. I wasn't saying it was to limit jurisdictional review. First of all, Section 67 is not a merits point. What I was simply saying, in effect, was to make it clear we're not saying that there is a limit by failing to go to the court of the Sikh. All I'm saying is that there may be a practical consequence in some circumstances. I don't put it any higher than that. I'm not saying that you are obliged to go, and therefore, because you don't go, you're limited. All I'm saying is if you don't go, and you may lose a ground under Article 5. But what this court is concerned with is what happens here when the award is before it for the purpose of enforcement.
Yes. I mean, presumably the whole convention recognised the reality of the situation, that somebody who is successful, holds an award, will want to enforce it as soon as possible and will go to the jurisdiction which offers the best prospect of a full recovery.
Well,
I mean, that's presumably why we're here. And therefore it seems silly to force people, as it were, to argue in the seat of where the award was made, if you can deal with the same issue. Yeah. Validity of the agreement
I
here.
agree with that. That's what effectively, because I think that because my learned friend's case has perhaps latched onto it in a different way, I was really trying to make that point. I think the only other point to make on enforcement is, of course, it's not necessarily that you could choose one country, but I mean, if there are assets spread all over, you could be seeking to enforce simultaneously or one after the other in several countries, depending on the size of the award. And where the assets are spread.
Anyway, as you say, we shouldn't waste too much time on this.
I just really wanted to dispel what I think had become a point which, in a sense, is not really critical to the submissions I make. I'm not taking you to the model law or the English or the French position that's set out in the case. I finally just want to make a few brief comments on the competence jurisdiction. Let me make it clear that we accept that the tribunal is not the final arbiter of its own jurisdiction. It is subject to review. It's been described by Gaillard as a chronological review. And it can happen at various stages. It could happen by way of a preliminary ruling under Article 16.3 of the Model Law or Section 32 in this country. It can happen by way of setting aside, and it can happen at the enforcement stage. But there is an important vital distinction to be made between the competence jurisdiction, which is the jurisdiction to determine whether or not that tribunal has substantive jurisdiction, in other words, to go on with hearing the merits, and the competence jurisdiction itself. And the conclusion of an exercise of a competence jurisdiction may be right or it may be wrong, but that tribunal pursuant to that competence jurisdiction still in our submission has jurisdiction to make the wrong decision. Now, it may be wrong and it can be set aside or it can not be enforced, but it doesn't undermine the initial entitlement of the arbitrators to make that decision. And that decision, again, even if right or wrong, remains binding. It may not be enforced because it's wrong, but as a partial award in this case, it is a binding award because the Convention recognises, as does the English statute, partial awards.
And how do you fit this into your argument in this case? I mean, I can follow the point you make.
It's background to the context when I'm coming to the review, which I will explain in a moment. But I just want to make this point clear, because what is said, and particularly when we come to discretion, is that the competence jurisdiction is based on consent. Now, what we submit is based on consent is the entitlement of the arbitrators to go on to hear the decision. If they decide that they haven't got jurisdiction, they cannot go on to hear the substantive merits. If they decide they have got jurisdiction but are wrong in that result, they still can't go on to hear it. But they still have the initial entitlement to make that decision. And that initial entitlement is not dependent on the consent of the parties, because it's a functional necessity of the scheme of international arbitration, which otherwise would grind to a halt if every time there was an issue as to whether an arbitrator appointed pursuant to an apparently valid agreement was or was not entitled to make that, if one describes it in this way, provisional determination.
Have you got any authority
Well, yes,
for the
my lord.
proposition that an award as to jurisdiction falls within the New York Convention? Because if it does, there seem to be some radical consequences.
Let me take you first of all to Volume 3 of the authorities. It is actually set out in the case, but
What's the case reference? Yes.
Of paragraph, sorry, it's set out in paragraph 108 of the case.
108.
Of my case.
Yes.
But you might just like to see it in context, which is at Bundle 3, Flag 105. Where it's a much larger extract. I won't read it all given time constraints, but if you go to, it's sort of towards the end of Flag 105, and it's the extract that begins at 396. I don't know whether your lordship have it.
Yes.
And recognition of the principle. This is from Gaillard's book, or Fouchard Gaillard's book. 653, the competence principle is now recognised by most international conventions.
Sorry, what page are we looking at? 397.
397. It's the smaller print. The competence principle is now recognised by the most international conventions on arbitration, by most modern arbitration statutes, and by the majority of institutional arbitration rules. As the 1958 New York Convention only deals with the conditions for recognition, it doesn't cover the competence principle.
Well, isn't that against your submission?
Well, no, with respect, because one has to look at how arbitration works in practice. And it is enshrined in most statutes, it's enshrined in our statutes, that the arbitrator...
Yes, I mean, I don't understand the difficulty, really. It seems obvious that if someone is appointed to decide almost anything, that person or body can consider whether...
they are properly appointed and have jurisdiction to decide whatever they're asked to decide. To elevate that further seems perhaps unnecessary, but perhaps the more important point is this doesn't seem to support the proposition that a partial award on jurisdiction is an award subject to the New York Convention. And if it were, I mean, why wouldn't it be bounding? Because, I mean, on your argument, competence delivers to the arbitrators under some international, generally accepted international principle jurisdiction to decide their jurisdiction. If so, there's nothing in Article 5 which would enable the government of Pakistan or anyone to apply to resist enforcement of that award or recognition of it. Well, and we would be bound to recognise the arbitrator's decision then.
But, my lord...
Wouldn't we? Isn't that the consequence?
Well, with respect, no. What we say is it is a binding decision, but you can choose not to enforce it.
Well, why? Under which head, if they've got jurisdiction to decide their jurisdiction under some general international principle, or you mentioned under some particular statute, I think Gaillard says the general international principle is to be found in the laws of all countries liable to recognise awards.
And there's also a section, I'm just looking for
Yes, but under which head in Article 5 would the government of Pakistan be able to resist the proposition that this is a binding decision on jurisdiction?
under Article 5, point
No,
1A.
No, that undermines your argument, because you just...
We wouldn't be able to say it's not binding. It would be saying, this is the point, my lord. There's a distinction between binding under Article 3 and enforceability. Because even if this court fails to enforce the award exists and can be enforced in another jurisdiction. The role of an enforcing court is not, however egregious what's gone wrong, it has not got the power to set aside the award. All it can say is we in this country will not enforce it.
Right.
Whether it's public policy or whether it's Article 5. But the award still exists as an international instrument. And I know that in a sense is difficult to comprehend when one's looking at it in a national context. But in an international context, that is the position.
But the only basis under Article 5, which treats recognition and enforcement in the same breath, on which the government of Pakistan will be able to say, sorry, the arbitrators were wrong on jurisdiction, is if the agreement is not valid, and that must be the agreement under which the arbitrators are ruling on their jurisdiction, is not valid. So how can their ruling have any validity at all? Certainly, how can it be... I simply don't understand where the argument, how it runs or where it goes, actually.
Because for the very point that I'm seeking to make, that the source of the jurisdiction is not the agreement.
I see.
The source of the jurisdiction is in the statute. For example, in England, it's Section 30. The English courts give the tribunal the power to determine their own jurisdiction.
Well, it seems to be some kind of underlying principle.
Yes.
I mean, that's the way it's expressed in the reference you've given us.
Yes.
But whereas the Convention is concerned with enforcement.
Convention is concerned with enforcement. And that is all the Convention in today's context is concerned with.
Yes. Well, this is why I asked you earlier, actually, how this all fits into the argument, because at the moment I can't quite see.
It only becomes relevant when we're looking at, really when we come to, we're coming to discretion.
Just one final point. Isn't this notion linked to the separability of the arbitration clause?
Well, there's debate about that. Yes, in one sense it is, although the commentators perhaps are not all ad idem about that. But that is right. It is it is separable, Section 7. But the point is that one has Article 3, and Article 3 says that it is binding. And of course, one cannot get over that, because what Article 5 doesn't say that it ceases to be binding. All Article 5 says it ceases to be enforced.
Yeah, but on the ground that the agreement's not valid.
Yes.
And how can you have something that's binding which is not valid?
Because it is a view of the enforcing court as to the validity of the underlying agreement. But it will not stop a party going to another country. Just because the English court says it's not valid, still entitles a party to go and enforce it elsewhere. Because the binding was one of the compromises that came out, and one of the progressions that came out of the New York Convention from the previous Geneva Convention, where they sought to avoid issues about finality, etc. And the compromise was the word binding.
I don't see what this has really got to do with it.
Well, my lord, I won't push it further, because it's really background, and I can come back to it as necessary. I'd really like now, if I may, to move to the review point, which is part 5. And
So whereabouts in your case now?
that is, sorry, I've renumbered it. It's part 5 of my case, which is paragraph 1, 2, 3. And I'm going to perhaps leave the case a little and make the points more succinctly, I hope.
Right. So
I've been, as your lordship would have seen, roundly criticised not only at all levels of the court today, but by my learned friend, for not being able to formulate some rigid principle as to what is the nature of the review. But I hope we'll be able to show that a flexible and nuanced approach enables justice to be achieved more readily than some unyielding statement as to how the court should approach the issue. Because any consideration of the nature and extent of an enforcing court's review, which is carried out according to its national procedures, must be able to accommodate a variety of potential situations which could come before it. Now, in this case, we have a unanimous award from an experienced and eminent tribunal sitting in Paris under the auspices of the ICC, producing a fully reasoned award, scrutinised by the ICC under its rules, seat in a sophisticated country where there's a sophisticated jurisprudence, where the respondent declined to participate at the oral hearings even without prejudice, as it was perfectly entitled to do, but the tribunal nonetheless produced lengthy, nonetheless their submissions were considered by the tribunal.
Issue has been taken with the brief reference, which is more extensive in your case, to the distinction of the tribunal, and personally I feel it's there's some force in the way in which issue is taken. Are we really to give credence to awards by reference to some assessment of the distinction, age, merits of the arbitrators? It strikes me as, courts do, I'm afraid, occasionally say, a very well known this or very distinguished judge, but usually of people who are dead. And it does seem to me it's actually slightly ageist in a way. You may have a brilliant 25-year-old who's infinitely more on the ball than someone as old as I am.
Well, I take your point, Lord Mans. I take comfort from the fact that it doesn't originate from me, but when one looks at the Canadian cases, which I've cited, the expertise of the arbitrators has been a fact that's been taken into account. I say no more than that.
And it is individualised, as in Canada. I mean, they're picking out particular people and say, oh, yes, A, B and C are particularly...
Well, I suppose in the sense that they would look at the tribunal in the particular case, yes. But, my lord, you must make of that. It's not the prime point in my case. Though what I do make of it, and will say, is that when I come to it, is that it indicates that different people in this particular case, on the same facts, can legitimately come to different reasons, and I'll come to that in a moment. At the other end of the scale, of course, you may have the single arbitrator who let's leave aside his eminence, but nonetheless writes the ill-reasoned and incomprehensible award. And all I'm saying here is that there is a pool of potential situations when one's talking about 144 countries that can arise. Moreover, of course, there's no system of precedent in international arbitration, and each case is determined on its own facts.
So when you said that they were unanimous, but of course it's rather more nuanced than that, isn't it?
Well, except this, Lord Collins, that if you have doubts, and if two have doubts as opposed to one having doubts, one has to assume that a lot more thought has gone into it before you actually agree to put your name to it. I mean, it sometimes happens that one has doubts, but here it would appear that two had doubts, and yet nonetheless they concluded that, I think the phrase was, conforms with the justice of the case. So one can argue it both ways. The government contend at paragraph 233 of their case that the enforcing court has to determine the issue of consent for itself, the onus being on the objecting party, and it continues, in making this determination, the court may have regard to the reasoning and findings of the alleged arbitral tribunal if they are helpful, but is neither bound nor restricted by them. Now, while it appears, therefore, to be accepted that the reviewing court can look at the award, one might ask rhetorically, helpful to whom? This test ignores the fact that what we are looking at here is not a challenge to the award, for instance, under Section 67. It's not an appeal, but it's a determination of whether a binding award can be enforced in England under the court's discretion on the ground that it wasn't a valid ground. So in our submission, the test helpful is unhelpful, because the award exists as a piece of evidence. The question is not whether it's helpful, but in our submission, what weight should be given to it and what deference should be paid to its reasoning. Because, as I said a moment ago, and this is why I went through it, it is a binding international instrument with an independent life, irrespective of whether or not one country chooses to enforce it. And so if one has a rehearing, of necessity, if you have a rehearing, you start from scratch, and you ignore the award other than by way of reference, because you start with a blank canvas.
Are you actually referring to a particular part of your case at the moment?
Well, I was trying to shorten it, because I'm referring to part 5 of my case. And what I was trying to do, because...
These particular points, are they set out in the case, or are they...
They are, perhaps in different ways, yes. I don't think there's... the only thing that's new, of course, is I have to deal with the phrase helpful, because I didn't have my learned friend's case. So I've adjusted it, and I've tried to make it shorter. It's set out at more length, but I've tried to keep the point shorter. I don't believe there's anything inconsistent. It may just be expressed slightly differently. But the fallacy of the government's argument is, in our submission, it reflects what would happen in the English court when looking at a case on appeal. And that's inconsistent with the pro-enforcement policy of the Convention.
Can I just take issue with one point, which
Yes.
you made several times? You say this is a binding award. If there is no agreement, then the only logical consequence, although an enforcing court can't declare it, of a decision by an enforcing court not to enforce on the ground that there's no agreement, is that there is no binding arbitral award. And actually that will normally give rise to an issue estoppel in every other enforcing court if common law principles apply that. Article 3 isn't saying that invalid documents are binding arbitral awards. What it is enunciating is a general principle that arbitral awards are binding if they are made, of course, subject to a valid arbitration agreement. And all that we said in Dallah and UKSC was that the onus is on the person resisting enforcement to prove that something which is apparently a valid and binding arbitration award is not, because there was no binding agreement. And the onus arises from Article 4, because all that the person relying on an award has to do is produce something which looks like, we said, a valid award. And Article 5 then throws the onus on the party resisting. But I don't think you can interpret Article 3 as conferring, making binding something which is actually, logically, a nullity once you've established the matters in Article 5, 1A.
If I can just digress for a second, your Lordship's point about apparently conforming documents, of course, applies not just to the award but to the agreement, because you have to lodge both.
Well, Article
That's
2,
the sort of mechanism that starts the ball rolling.
But none of them are actually binding. It's simply that the onus of proving they're not binding is on the person resisting enforcement. At least once you've got to a certain point of something that looks like, on the face of it.
My Lord, I can see the logic of that, but the other side to the logic is that if that is right, why would this award not be binding? Why could a party not go and seek in another country to enforce the award?
Sorry, what is right?
If your Lordship is right, and this country set aside the award as invalid...
No, it wouldn't. This country would simply refuse to recognise it. It would say there wasn't an agreement. This is just as good as a newspaper article. It's not an award. Other countries might allow the same issue to be relitigated if they didn't have a doctrine of issue estoppel. But assuming they did, and I think many countries do, they would say, sorry, it's been decided in England.
Yes, but I think with respect, there's maybe we're at cross purposes. What I'm not saying that this court can't say when it is seeking to enforce that the agreement is not valid. Yeah. I accept that because that's the ground upon which my learned friend has to establish. But what I'm saying is that as an instrument, the award in practice, it's not enforced here, and that's all that matters for the English courts. But in practice, that award, even though the English courts have said the agreement is not binding, that award as an award remains. And one can see that in other examples.
Well, subject to the only purpose of it remaining is for it to be enforced elsewhere.
Indeed.
And it can only be enforced elsewhere on that hypothesis in countries where there's no similar doctrine of estoppel.
Well, I'm sorry, Lord Collins, I'll answer that in a second. Yes.
No, please answer.
What I was going to say, I haven't really come to it yet, but Article 7 provides a favoured right provision. And you may have seen in the Court of Appeal decision, Lord Justice Ricks in particular deals with this. And there are cases, I think my learned friend's going to show you, but there are cases such as Hillmartin and Cromley where an award has actually been annulled in the seat, and yet countries have enforced it. So the point being that the status of the award...
Under which article is that?
This is not part of English law, it's Article 7.
No, but under the Convention.
Under the Convention, yes.
It's the second part of the article, is it?
It's the second part of it.
I mean, if it were sorry.
Well, there's a distinction between the status of the award in the country where it's rendered and its status internationally.
Yes.
In the country where it's been rendered, of course, it can be set aside, just as any award can be set aside in any country. Internationally, prima facie, under Article 3, any award is binding, but it is and enforceable and recognisable in other countries subject to the New York Convention, but it says under the conditions laid down in the following articles. So you can't separate the binding character of the award from the grounds for non-enforcement and non-recognition.
Well, my Lord, as I say, the point we make is not that the English courts can only have a limited role in this country. They cannot determine what other countries will do because that award still exists. And I give you the example of Article 7, which entitles, even if set aside, it entitles a country to enforce an award. And setting aside an award is stronger than not enforcing it. My Lord, that in a nutshell is our submission, that the role of the enforcing court is to make a decision on the enforceability, which is a different decision from the making a decision as to the underlying nature of the award. The practical consequence simply means that even in any event, if I'm wrong on that, the starting point for the purpose of the consideration, which is what we're discussing today, is that it is a binding award. Because until this court, as the enforcing court or any enforcing court, comes to its conclusion, it doesn't conclude that it's either unenforceable or not binding.
But all that's really irrelevant, isn't it? There's only one question for the court in this class of case. Was the agreement valid? That's the question. That's the only question the court's addressing.
That's the question.
Doesn't really matter whether the award's valid, how you categorise the award at all. There's one question: was the award valid? Was the agreement valid?
Yeah.
And on that question, it's common ground that the burden of proof is upon, in this case, the government of Pakistan.
Indeed.
And that's all there is to it. So that's the question. The thing is to get on decided on the facts.
Well, that
You say, oh, well, it's all more nuanced than that, and it's not easy to see how you fit a consideration of that question, how you fit into a consideration of that question. You know, the respect you give to the arbitrators. I don't know.
Well, what happened here was the English court started with a blank sheet.
I mean, this is really, I think this is your point, really, that they should have started by assuming that this was an award which should be recognised. That should be the starting point. Well, is that it? And therefore...
No, that they should that it is a binding award,
Yes.
and therefore it is a piece of evidence. It cannot simply be looked at if it is helpful. That the court has to consider it. It is faced with a binding award, or whether you agree with me or not that its role is simply to enforce or not enforce, or to declare it's not binding by virtue of the fact that there isn't a valid agreement. The starting point for an English court is not to say, I, the English court, am going to look at all the facts again. Effectively, if it's helpful, I'll look at the award, as is said against me. It has to look at the award and give such weight in the circumstances to that award in the context of, as Lord Clark says, the onus being on the government to prove to the contrary.
Presumably you'd only give weight to it if it was helpful, I suppose.
Well,
It might be incoherent.
Sounds to me as if the existence, to take I hope a topical analogy, the existence of the award not only entitles you to start serving, but entitles you to start serving at 30 love up.
well, not necessarily, my lord. It would depend on the circumstances of the case. If you had a one-page award which said X is a party, my learned friend comes along and says, but the name's wrong. I have the certificate here from the company's house registry saying clearly this is wrong. Then clearly the English courts would give very little attention to the award. But where you have here a case where there is no new evidence brought by the government, and on what we say is a result which was not a result which a tribunal could not have come to on the facts, you must give weight to that award, where you have a fully reasoned award.
So do you say that the principles are those that are applied by the Court of Appeal to the question whether a judgment is on the facts? Take any case, there's judgment on the facts. It's very difficult to persuade the Court of Appeal to upset that, and there are a whole lot of relevant principles. Now, are you saying that that's the principle, or some different principle?
It's a variant because it's not an appeal. One's not this.
But how different is the approach that you're advancing or suggesting from the approach that the Court of Appeal takes to appeals on the facts?
There is a certain similarity in the sense that.
Well, how are they different? Is it a more or less taxing?
Well, why we say there has to be a flexibility is because here you are talking with a much greater variable of situations than you will be in a national.
Well, so are you in an appeal?
Well, yes and no.
Depends how hopeless the judge is.
Do you say that the arbitral tribunal was, even if it was wrong, was entitled to come to the conclusion it did? Is that the way you put it?
No, if the English court, looking at the award, came to the conclusion that the government had produced sufficient evidence that it was so clearly wrong that it was unsustainable, then of course the English court would have to not enforce it. But there are a variety.
Well, that is more or less the Court of Appeal test.
Yes.
I mean, where you put it in paragraph 135 of your case is that it's got some inherent evidential value. That's really what I think the argument comes to.
What's the evidence of?
I'm sorry.
I'm sorry, I shouldn't have interrupted.
Yeah, I mean, it's the evidence of what the arbitral tribunal thought and what it made of the evidence it had before it. I mean, it itself, you say, I mean, I'm simply trying to focus your argument by reference to the writing in the case, is that it has evidential value, and therefore, because it's part of the evidentiary matrix, you don't start de novo, and therefore the test that the judge set for himself, which you quote in 134, is wrong, because he goes back to the very beginning. And he finds that his starting point in the terms of the statute, which doesn't talk in terms of review at all. It just simply puts a question in effect.
I accept that, and that is why there is an issue to be determined by this court, because it's an issue which hasn't actually been resolved, certainly at this level, as to whether, unlike the Section 67, which is accepted as a rehearing, what is the standard of review that an enforcing court, as opposed to a setting-aside court, should adopt when looking at an international convention award. If I can just have another stab, I mean, there are various ways you could put it, but another formulation is that the review relates to whether or not the government has proved that the government has to prove a negative, that it didn't consent to arbitration, and whether in the exercise of the discretion the court should refuse to enforce the award. And where we part company with the formulation of the government is that in considering this issue, the court must, not may, consider the award and its reasoning and findings, and must give such weight as appropriate in the circumstances of the case in hand to that award as a piece of evidence, together with the other evidential mix and the other factors in the case. And it cannot be just as in an appeal, it cannot be an absolutely rigid situation, because you will have a variety of different types of situations that will arise. There will be cases where there is compelling new evidence. To give you an example in a completely different context, the case of Canoria, which was a procedural issue, the tribunal went ahead and heard a case where new points were made at the hearing, where the respondent unfortunately was severely ill and didn't have an opportunity to present his case. And it was late in the enforcement hearing that it became apparent that he had not had this opportunity and that new points had been put at the hearing. And in that case, it was the only case where the New York Convention had not been set aside. The gentleman had cancer and had been ill for over a year. Lord Phillips, I think was the judge, said that there would be severe injustice, and clearly this was a case where there was new evidence which indicated a completely different state of affairs.
But
So,
what is wrong with Mr. Lendall's approach, which I think is to say this: look at the award. I can make, I think it's 11 criticisms set out in Appendix A, the things that they quite obviously got wrong, he says. You say, give it such weight as is appropriate in the circumstances. He will say, well, you can't really give it any weight at all because it has these mistakes, and therefore it's proper to start again and look at the matter afresh. Is there anything wrong in that on your approach?
There are two differences. One, he says may.
Sorry?
One, he says you may look at the award. We
Yeah.
say you have to consider the award because it's a piece of evidence. And two, he says whether or not it is helpful. In my submission, helpful is not an appropriate test. You have to consider it in the context of what weight you attribute to it. And it may be helpful to one side, it may be helpful to the other side, but helpful is not, cannot.
Well, he is considering it. Look at Appendix A. He looks at it, analyses it, and says, well, there are these errors, and perhaps he doesn't need all of them. But he says, given those, really, the sensible thing is to have a fresh look at it.
Well, yes, but that's not a helpful test, that's a weight test. But the weight test in this case, and the point in this case, is that what you have is a case of an interpretation of facts. The basic facts are not really in dispute. It's the interpretation of the facts according to principles of law which are not really in dispute, because the French law is agreed.
Well, yes, but I mean, there is a problem, which is a more detailed problem, perhaps a second-tier problem, that you're not actually seeking to uphold the arbitrator's evaluation of the facts, are you? They decided the case on the basis of alter ego, which you're not pursuing.
Well, with respect, my lord, not by any means exclusively. I mean, your lordship will have seen that they went through it. First of all, the test in paragraph 6 of the partial award was a test I put to their French witness, and he agreed that that was generally the correct test. And they then expanded upon that in paragraph 7 and said, well, you look at it at the 4 stages. And they did examine it at the 4 stages. Yes, of course, they did deal with the alter ego, but it is sustainable, even if you ignore that, because it's consistent in our submission with the facts of this case. And just to make this, there is a practical reason as well. In enforcement, the result of having a complete rehearing from scratch, of course, can mean that an enforcement of an award, which is supposed to be a simple procedure, can take several days. Now, in our case, I think it was 3 days, I may be wrong, but in Svenska it was 4 to 5 days, where the English court effectively rehears everything from scratch again.
But, I mean, how is your flexible and nuanced approach going to alter that? We're going to be asking, well, how flexible and how nuanced in the light of the 11 points which are made in Annex A or 1 and the points which are made in Annex 2 and so on. It seems to me there's really going to be no difference. It's chalk and cheese.
Well, there may be, or one can say, but the point also is emphasised, and I set it out in the case. Although it was early days, it was the government's views in the Travo, which I've set out in the case. And just to give you the references,
Paragraph.
it's
In the case?
In the case, sorry, it's paragraph 138. But if I can just give you the references in the volumes, it's volume 1, tabs 13 and 15, where in particular, if you look at 13, sorry, at paragraph 139.
Is this quoted in your
It's quoted, yes.
Yeah.
So you need to turn it up. But if you want to read the whole document at a later stage, those are the references.
And which of the paragraphs quoted at 138?
It's paragraph 138 is from volume 113, and 139 is from volume 115. Where clearly what was expected was not a full re-examination.
Well, wait a minute. I mean, paragraph 139, according to the government of Pakistan, this is the view of one non-governmental organisation which didn't have a vote.
Well, I don't want to...
The Society of Comparative Legislation. We can't give weight to that as indicating, can we?
Well, the 139, I was going to mention. My Lord, this was simply what was behind, amongst other things, the New York Convention, that they wanted a speedy procedure. I'm not sure we need to even overemphasise that. That is clearly implied in the New York Convention. But, my Lord, can I just...
Sorry, I want to catch you before you move on. I'm looking at paragraph 138 of your case, paragraph 9.
Yes.
That long quotation.
Yes.
The second and third sentences. Because
Yes.
one has to appreciate that the grounds on which you would want to refuse enforcement could vary. I mean, there are people who disagree with the award on its substance. Now, we're not dealing with that kind of issue here, but one can quite see that there's a very strong resistance against opening up awards on their merits, and one knows that that's absolutely fundamental to an understanding of the way the Convention works. On the other hand, if you've got something which is safeguarding, as it puts, the basic rights of people, then nothing can be more basic, can it, than the fact that you're being faced with an award based on an alleged agreement to which you weren't a party.
Well,
And why shouldn't one
entirely.
look at that and give it a thorough examination to see whether or not this really was an agreement to which the individual or the party was really a party?
Well, I accept that entirely. On the other hand, you have to balance sometimes. I'm not saying it's in this case at all, but in some cases, it may just be a way of delaying matters. So that's another factor one's got to consider. Parties can object to recognition and enforcement as a means of delaying the inevitable.
Well, I mean, in this case, nobody
I'm
can pretend
not
that.
saying it's this case.
It's not uncommon. I mean, we've got no statistics, but experience indicates to a certain degree that it's not uncommon to find people asserting arbitration agreements in circumstances where they don't exist or they're hotly denied as existing. And there is an important general point about whether one should accept a regime which allows that to happen, provided it's not too flagrant. And
Well, my Lord, but that's the other side of the coin, of course, of people, as I said, not here, but people trying to play with the system.
I mean, if your case is that you're not a party to the agreement,
Yes.
you're quite entitled, aren't you, to say, well, I'm not going to have anything to do with the arbitration at all. I'm simply not going to. I'm not going to address any evidence to it. I'm going to wait until somebody tries to enforce any award against me, and then I'm going to have a trial then.
I accept
Now,
that.
well, you don't really, because you're saying you can't have a proper trial then. I'm not going to go to the arbitrators. I'm not going to put any evidence for the arbitrators. I'm going to wait. I'm going to wait till I'm sued in England where I've got all my assets. I'd rather have a trial on that question then, and I'm going to do that.
But,
I've deliberately chosen to do that, and I'm now going to deploy 25 witnesses on the complicated question of whether I'm a party or not. Now, is that an improper thing to do or not?
They're entitled to wait. That
Yes. Well, when they get there, can the court say, well, you're just a troublemaker, I'm not having any of that?
Well,
Subject to the sort of Order 14
I mean,
type
it may be that it's part of the case management process, but it will depend upon on the case, obviously. As I said, if you have a situation where you have a one-page award and you have strong, compelling evidence, then clearly it's a very different situation. Where you have, as here, a situation which, on any view in our submission, is finely balanced on the facts. And therefore, we would submit that you have to look at the award and give considerable weight to that award in looking at that fact. And if I can just, I've got 5 minutes, if I could just,
Of course, yes,
before almost concluding this point, just take you, because I'd mentioned it but didn't take you to yesterday, just a couple of other documents, just to indicate to you and to bring home the point that this is in some ways an unusual case because there is no new evidence. And it's a question of different lawyers, because they're lawyers at the end of the day, the arbitrators, interpreting the same facts in different ways and trying to interpret an objective behaviour subjectively. And if you would kindly just take up Bundle D, tab 8, because this was something I read to you from the award, but perhaps highlights, and is more also relevant when we come to discretion, the inconsistent...
Which part of tab 8? Is it...
D tab 8, the inconsistent approach of the government in this case. It's a letter of the 17th of November 1999,
Yes.
written to the chairman by Walter Martin Salim, and it's the second page. The legal effect of the letter of Luftfuller Mufti, Secretary, Ministry of Religious Affairs. Admittedly, the trust lapsed on 12th December 1996. Thus, trust established under the ordinance ceased to exist with effect 12th December 1996, and all of its office bearers, including the Secretary of the Board of Trust, i.e. Secretary of Ministry of Religious Affairs, also ceased to have any authority to act for and on behalf of the trust. The letter dated the 19th of January 1997, written by the Secretary, Ministry of Religious Affairs, and addressed to the claimant, was therefore absolutely unauthorised, illegal, and of no effect.
So this is written on whose behalf?
On behalf of the government.
Well, what's wrong with that?
Yes, what? I mean, that's precisely their case, isn't it?
Well,
The letter purports to be written on the trust, but it couldn't be.
well, it disowns the letter entirely. This was the point that the tribunal made. At one point, it argued that it's a letter written on behalf of the trust. At another part, it's a letter that shouldn't have been written at all.
But it's plainly what it said. It's a letter purportedly written on behalf of the trust. It certainly doesn't say it was written on behalf of the government.
No, I'm not saying it does. And what I'm saying is they disown. They don't deny in this to say that it's not written by the government. The whole letter is disowned as a letter. And one has this contradictory approach of the government.
There's undoubtedly been a bit of ducking and weaving.
There has undoubtedly been some ducking and weaving. And when one goes just further on to... what's the paragraph of the witness statement?
I mean, you have to read B as well, where it's plainly asserted that the government's not party to the agreement.
And just one final thing. Or perhaps I can come back to it rather than detain you. I'm conscious of the time. My Lord, when I just take you to this other document. Thank you.
When you do come back from it, could you help me on where you get the word review from in part 5 of your submissions?
Review.
The word, it's constantly used
Well,
during the course of those submissions. It doesn't appear in the Act, does it?
It doesn't appear in the Act.
Does it appear in the Convention?
Doesn't appear in the Convention, but the answer, neither does the word rehearing. There isn't a word used. The academics talk about the jurisdiction being subject to a chronological review, and it was, so to speak, a neutral word that accommodates what this enforcing court has to do.
But isn't it clear, we're back to the point we're on before, Article 5(1)(a) says that what the court has to decide, the enforcing court, is whether the agreement was valid. And that's the question. No doubt it has to have some regard to the award, I can quite see that, but isn't that about all there is to it?
Well, I
over-analysis.
made my points, my lord. I mean, we say that it's not an issue that you start from scratch. And you have to remember also the introductory words, which is that the enforcement may be refused. So that brings in the discretion if one of the grounds. So one's looking at it slightly. It's not, that is the gateway, but of course, although it comes
Doesn't the discretion must come in the second?
Logically, it comes second, but in fact...
Discretion can't be relevant to the question whether the agreement was valid or not.
Logically, it comes second. But actually, the way it's written in the article is that it's the introductory word. But logically, I accept it comes second.
Well, I think we perhaps should stop
Yes.
there in view of the time.
I will finish comfortably in an hour.
Very good. Well, we'll look forward to seeing you at 2:00.
Thank you. Is it worth,